Hey, it's Mr. Portland Landlord. If your leasing life lives inside AppFolio, Buildium, Rentec, Zillow applications, or a smart lock app, Oregon just wrote a new rule on top of it. It is called the Oregon Tenant Portal Law 2026, Senate Bill 1523, and it is now Oregon Laws 2026, Chapter 23. It took effect June 5, 2026. Here is the whole bill in one sentence. It does not ban portals. It bans making the portal the only door. You can keep the software. You cannot make housing, rent, signatures, or the laundry room door depend on a login. So what actually counts as a tenant portal? The statute added a definition to ORS 90.100. A tenant portal is any electronic application, software, website, or digital platform provided by you or on your behalf that an applicant or tenant uses to apply for, start, keep, or end a tenancy. That net is wide on purpose. Your property management platform counts. The online application on your website counts. A listing site that takes applications for you can count if it is acting on your behalf. A lock app that is the only way into the building can count. What does not count? Email and text with you or your agent. The legislature carved those out. A PDF application returned by email is not using a tenant portal. A tenant texting "the sink is leaking" is not a portal ticket. You can still prefer the software. You just cannot pretend email stopped existing. And you may keep entering paper and email information into the portal. The filing cabinet can be digital. The front door cannot be digital only. If you use a portal to accept applications, you have two jobs. First, either post a printable application on your website, or, within 7 days of a written request, mail or email a printed or printable copy. No website? Fine. The 7-day response is your compliance path. Put that on a calendar, not in someone's head. We'll get to it after showings is how you buy a $100 statutory claim plus actual damages. Second, you process every application, portal or not. Same screening criteria, same completeness rules, same place in line. You do not get a shadow pile labeled paper, deal with later. Inside Portland City limits that second duty sits on top of the city's application and screening rules. If you advertise an open window, first-come processing, or a published unit availability notice, a paper packet that arrives during that window is in the queue. Timestamp it when it hits your hands or inbox. Do not let the portal's auto-stamp decide the race while a complete paper file sits on the printer. Screening charges under ORS 90.295 still exist. Senate Bill 1523 did not repeal them. It just says the method of delivery cannot be the filter. On written request, you may not make the portal the sole way to verify identification, review and sign addenda or other legal agreements, or submit tenancy documents. That is the "my phone died and I still live here" clause. A tenant who wants to sign a parking addendum at the kitchen table gets a wet ink or emailed PDF path. An applicant who will show a physical ID at a showing instead of uploading it through the app gets that path. You do not have to guess. The trigger is a written request. Once it arrives, document it, offer the alternative, and keep moving. You can still use the portal on your side. You cannot hold the tenancy hostage to a password reset. Miss this piece, and the penalty is actual damages or $100, whichever is greater. It is not a lottery ticket. It is also not worth defending in small claims because you like the software better. And now, I have a couple of shameless plugs for you today to help you stay ahead of these laws. If you are rewriting application instructions and payment language this month, do not invent it on a napkin. Members of the Portland Area Rental Owners Association, PAROA, get current Oregon landlord forms, education that tracks the short session, and a helpline that has already started hearing payment technology questions. That is the point of the association. You are not supposed to decode Chapter 23 alone at 10 p.m. And if you own in the Portland Metro or Central Oregon and you would rather not run 2 intake tracks by yourself, Northwest Real Estate and Property Management, NWRPM, already does this work. Printable applications, check and portal payments, and files that survive a written "please don't make me use the app" request. Sometimes the compliance cost is just hiring the shop that already built the process. Okay, back to the part that will show up in a courtroom first. Payments. A landlord shall allow a tenant to make payments by check or other commercially reasonable methods. You may not require debit card, credit card, electronic check, tenant portal, or any other electronic payment. If you refuse a permitted payment the tenant actually offered, you may not tack on a late fee or terminate for non-payment based on that refusal. Read that last part twice. The trap is not portals are illegal. The trap is this. Rent is due the 1st. Tenant tenders a check on the 4th. Your office says we only take AppFolio. On the 8th, you serve a 72-hour notice under ORS 90.394. That notice is sick on arrival. So is the late fee under ORS 90.260. Commercially reasonable methods include a personal check, a cashier's check, and a money order. Cash is commercially reasonable too, but the statute does not force you to keep a cash drawer. A no-cash policy is still fine if a check or money order will close the books. What about the tenant who bounced last month? NSF fees under ORS 30.701 still exist. After a dishonored check, requiring certified funds is a commercially reasonable method. Requiring only the portal is not. Do not write after 1 NSF. Electronic payment is mandatory. Write after 1 NSF. Certified check or money order. Update the lease. A portal-only payment clause on a deal signed in 2024 is not grandfathered. Chapter 23 applies to rental agreements entered into before, on, or after June 5, 2026. ORS 90.302 still limits what you can charge. Senate Bill 1523 rewrote the old credit card pass-through language. You may pass through processing fees. The processor charged you for a credit card, debit card, portal, or other electronic payment only if all three are true. 1. The payment company allows the fee to be passed to the payer. 2. You still allow non-electronic payment. 3. You produce records of those fees within a reasonable time after a written request. That is a receipt trail, not a vibe. If your software buries a convenience fee that is larger than what the processor actually billed you, you are not in the safe pass-through box. You are in the illegal fee box, and the tenant can chase twice actual damages or $300, whichever is greater. Put the pass-through in the written rental agreement. Keep the processor statements. When someone asks in writing, send the statement, not a shrug. Senate Bill 1523 also amended the habitability access language in ORS 90.320. If tenants use an app to open the unit or common areas, lobby, laundry, garage, bike room, you must offer at least one means of access that is not the tenant portal: a metal key, a fob, a key card, a keypad code that works when the phone is dead. Portland rain and a 2% battery are not a legal theory. If the only way into the building is a download, you have a habitability problem wearing a tech hoodie. Issue the backup at move-in. Put it on the condition report. When a tenant loses the fob, you can still charge a lawful replacement cost for a tenant-requested extra key. What you cannot do is say reinstall the app. Walk your stack once this week. If you take online applications, post a printable PDF or script the 7-day mail or email response. Train whoever answers the phone. Process paper and portal files in one line. Rewrite payment paragraphs so check, money order or cashier's check is always available. Kill electronic payment required. Keep NSF rules in certified funds language. Confirm every card or portal fee is a true processor pass-through, disclosed in the agreement with statements you can produce. Check the locks. Every tenant who needs common area access gets a non-portal way in. Log written requests for alternatives. Date them. Note what you provided. That file is how you stay out of the $100 column. None of this requires you to go analog. It requires you to leave an analog lane open. Quick question for the comments, and I actually want the answers. Are you still portal only on applications, on rent, or on building access? And which of those three is the hardest to unwind in your software? Tell me what your platform will and will not let you turn off. Senate Bill 1523 is not a war on property management software. It is a reminder that a tenancy is still a human relationship with a paper trail. Keep the portal. Keep a printable application. Keep a path for a check. Keep a key that works when the phone does not. That is the whole assignment. Hey, if you're a Portland area landlord, come join the community over at www.paroa.org. We've got education, forums, networking, and we fight for your rights at the legislature. And for owners in the Portland Metro or Central Oregon looking for hassle-free management, check out the pros at www.nwrpm.com. Thank you for watching this professional update. Keep your property management professional and your Portland properties compliant.